Hello, everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. Well, in today's video, we will be talking about discover 9 ways to secure a green card without leaving the U.S. If you're currently in the U.S. and your visa has expired, don't panic. There are still pathways available to obtain a green card without having to leave the country. Navigating the U.S. immigration system can be complex. But understanding your options can make a significant difference in your journey toward legal permanent residency. In this video, we'll explore 9 strategies that could help you secure a green card while staying right where you are. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe. And don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. If you've overstayed your visa in the United States, the path to securing a green card can seem daunting. Overstaying your visa can trigger various immigration consequences, including the potential imposition of a 3-year, 10-year, or even a permanent bar from re-entering the U.S. if you were to leave and try to return. Understanding the nuances of your overstayed visa situation and exploring your options for adjusting your status without leaving the U.S. is crucial. This guide will delve into 9 potential avenues to secure a green card while remaining in the country, each with its own set of requirements and processes. 1. Family-based sponsorship by a U.S. citizen relative. One of the most common ways to adjust your status and obtain a green card without leaving the U.S. is through family-based sponsorship. If you are an immediate relative of a U.S. citizen, specifically a spouse, an unmarried child under 21, or a parent of a U.S. citizen, you may be eligible for a green card through an adjustment of status application. The immediate relative category is advantageous because it does not require a visa number to be available and is not subject to long wait times like other family-based categories. Eligibility. You must have entered the U.S. legally. Even if you have overstayed your visa, the overstaying period or unauthorized employment does not disqualify you if you are an immediate relative of a U.S. citizen. Form I-130. Your U.S. citizen relative needs to file Form I-130, Petition for Alien Relative, to establish the relationship. Form I-485. Concurrently, you will file Form I-485 application to register permanent residence or adjust status. This form allows you to adjust your status from a non-immigrant to a lawful permanent resident while remaining in the U.S. Processing time. The entire process typically ranges from 10 to 23 months, depending on various factors, including USCIS workload and case complexity. Costs. Filing fees for Forms I-130 and I-485 range from $1,340 to $3,000, depending on your age and additional services required. 2. Adjustment of status through marriage to a U.S. citizen. Marriage to a U.S. citizen is another pathway to obtaining a green card. However, this process involves scrutiny, especially if you entered the U.S. on a non-immigrant visa and married shortly after arrival. Immigration authorities will closely examine your marriage to ensure it is bona fide and not solely for immigration purposes. Eligibility. If you are married to a U.S. citizen, you can apply for a green card even if you have overstayed your visa, provided you can demonstrate the authenticity of your marriage. Forms. Your spouse will file Form I-130 and you will file Form I-485 to adjust your status. Additionally, you may need to provide extensive evidence of the legitimacy of your marriage. Scrutiny. Be prepared for rigorous scrutiny. Evidence of a genuine relationship, such as joint financial documents, photographs, and affidavits from friends and family, will strengthen your case. Processing time. The average timeline for this process is similar to the immediate relative category, ranging from 10 to 23 months. 3. T-visa for victims of human trafficking. The T-visa is designed for individuals who have been victims of severe forms of trafficking in persons trafficking. In persons trafficking involves forced labor or sexual exploitation through coercion, fraud, or force. Eligibility. You must demonstrate that you were trafficked into labor or sex exploitation and that you have cooperated with law enforcement in investigating or prosecuting the traffickers. Form I-914. To apply, you need to file Form I-914, Application for T non-immigrant status, along with a detailed account of your trafficking situation and evidence of cooperation with authorities. Benefits. The T-visa not only offers a pathway to a green card, but also provides protection from deportation, work authorization, and eligibility for Social Security benefits. Family members, including children under 21, may also derive benefits from your status. Processing time. The T-visa application process can take between 18 to 36 months after obtaining T-visa status. You must wait for 3 years before applying for a green card, extending the total processing time to approximately 5 to 6 years. Costs. There is no government fee for filing a T-visa application, but legal fees may apply, especially if you seek assistance from an immigration attorney. 4. Violence Against Women Act Self-Petition. VAWA provides a pathway to a green card for individuals who have been victims of abuse by US citizens or lawful permanent resident spouses, parents, or children. Unlike other forms of relief, VAWA allows self-petitioning without requiring the abuser's participation. Eligibility. You must show that you were subjected to physical or emotional abuse by a U.S. citizen or green card holder, and that you are a person of good moral character. Forms. You will file Form I-360, Petition for a Malaysian Widow, or Special Immigrant. Under VAWA, you may also concurrently file Form I-480. 5. For adjustment of status. Processing time. The VAWA process can take approximately 2.5 to 3.5 years from filing to receiving a green card. Costs. There are no government fees for filing VAWA forms, but legal assistance may be necessary to navigate the complex process. 5. U-Visa for Victims of Serious Criminal Activity. The U-Visa is available to individuals who have been victims of serious crimes and have cooperated with law enforcement. This visa provides temporary legal status and work authorization while you wait for your green card. Eligibility. You must have been a victim of a qualifying criminal activity, such as domestic violence or sexual assault, and must have assisted law enforcement in the investigation or prosecution of the crime. Form I-918. To apply, file Form I-918, Petition for U non-immigrant status, along with Form I-918 Supplement B, Certification from law enforcement. Processing time. Due to high demand, the U-Visa process can be lengthy, often taking 5 to 6 years for initial review and up to 20 years to receive the U-Visa status once approved. You must wait 3 years before applying for a green card. Costs. There are no government fees for the U-Visa application, but legal fees may apply for assistance with the process. 6. Asylum. Asylum protects individuals who have suffered persecution or have a well-founded fear of persecution in their home country due to factors such as race, religion, or political opinion. Eligibility. You must apply for asylum within 1 year of your arrival in the U.S., though exceptions exist for extraordinary circumstances. Form I-589. File Form I-589, Application for Asylum and Withholding of Removal. This initiates the asylum process. Processing time. Due to significant backlogs, Asylum applications can take up to 6 years to be scheduled for an interview after being granted asylum. You must wait 1 year before applying for a green card. Costs. There are no government fees for the asylum application, but legal assistance is recommended due to the complexity of the process. 7. Section 245 I. Adjustment of status. Section 245 I. Allows certain individuals who entered the U.S. unlawfully but have a qualifying immigrant petition or labor certification filed on or before April 30, 2001 to adjust their status without leaving the country. Eligibility. You must be the direct or derivative beneficiary of an immigrant petition or labor certification filed before April 30, 2001 and have maintained continuous presence in the U.S. Forms. File Form I. 485. Application to register permanent residence or adjust status, along with an additional penalty fee of $1,000. Processing time. The adjustment of the status process can take between 10 to 30 months, depending on individual circumstances and US's processing times. Costs. In addition to the $1,000 penalty fee, you will need to pay standard processing fees for Form I-485. 8. Special Immigrant Juvenile Status. Special Immigrant Juvenile Status is designed for children who have been abused, abandoned, or neglected by one or both parents. It offers a pathway to a green card for eligible minors. Eligibility. You must be under 21, unmarried, and declared dependent by a juvenile court in your state. You must also be unable to reunite with one or both parents due to abuse, neglect, or abandonment. Forms. File Form I. 360. Petition for a Malaysian, widow, or special immigrant, and later Form I. 485 for adjustment of status. Processing time. Special immigrant juvenile status applications typically take 8 to 12 months to process, with additional time required for green card processing based on the visa bulletin. Costs. There are no government fees for the Special Immigrant Juvenile Status application, or Form I-485, but legal fees may be necessary. 9. Cancellation of removal. Cancellation of removal is a form of relief available to individuals in removal proceedings who meet specific criteria, including long-term residence and demonstrating that their deportation would result in exceptional hardship to their U.S. citizen or lawful permanent resident spouse, parent, or child. Eligibility. You must be in removal proceedings and demonstrate that you have been in the U.S. for at least 10 years, have good moral character, and that deportation would cause exceptional hardship to your qualifying relative. Forms. The process involves appearing before an immigration judge and presenting evidence of your eligibility. Processing time. This form of relief can be complex and may take several months to years to be adjudicated, depending on the caseload of the immigration court. Costs. There are no specific government fees for cancellation of removal, but legal representation is often necessary. Navigating the path to a green card while overstaying your visa requires careful consideration of the options available to you and an understanding of the specific requirements for each consulting with an immigration attorney can provide valuable guidance and increase your chances of a successful adjustment of status. Remember, each case is unique, and professional advice tailored to your situation is crucial in making informed decisions. Securing a green card while overstaying your visa is indeed challenging, but it's not impossible by exploring these 9 methods. You can better understand the potential avenues available to you. Always consult with an immigration attorney to get personalized advice tailored to your specific situation, remember. Taking informed and timely action can significantly impact your chances of achieving legal residency in the U.S. that is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you're doing great. Well, in today's video, we will be talking about discover 9 ways to secure a green card without leaving the US. If you have overstayed your visa in the US, there are several ways to potentially secure a green card without leaving the country. One option is family-based sponsorship, where immediate relatives of US citizens such as spouses, unmarried children under 21, or parents can apply for adjustment of status. This process involves filing Form I-130 and I-485 and typically takes 10 to 23 months to complete. Another route is through marriage to US citizen, allowing you to adjust your status without leaving the US. You need to provide substantial proof of genuine marriage to avoid scrutiny. The processing time is similar to family-based sponsorship. For victims of human trafficking, the T visa provides protection and a pathway to green card. Applicants must file Form I-914 and demonstrate cooperation with law enforcement. The process takes 18 to 36 months, with a green card application possible after 3 years. The VAWA Violence Against Women Act self-petition is available for individuals who have been abused by US citizens or lawful permanent residents. By filing Form I-360, you can secure a green card within approximately 2.5 to 3.5 years. For victims of serious crimes who assist law enforcement, the U visa offers a chance to apply for a green card after a lengthy wait. The U visa process takes 5 to 20 years, with a green card application possible after 3 years of holding the visa. Asylum is an option for those fearing persecution in their home country. Applicants must file Form I-589 within 1 year of arrival. The wait time for an asylum interview can be up to 6 years, with the possibility of applying for a green card after 1 year of being granted asylum. Other options include Section 245I adjustment for those with qualifying petitions filed before April 30, 2001, Special Immigrant Juvenile Status (SIJS) for minors abused, abandoned, or neglected by parents, or cancellation of removal for those in deportation proceedings. Consulting an immigration attorney is advisable for tailored advice and to navigate these complex processes effectively.